2013 and Trimega Laboratories, under new ownership and newly accredited to ISO 17025, are back before a judge having to explain errors. This judgment is given in relation to applications by 4 parties to care proceedings for wasted costs orders against Trimega Laboratories Limited, Trimega. The applications arise out of an error made by Trimega in a report following blood alcohol testing. Central to these proceedings was the mother's now acknowledged excessive drinking. At the final hearing on the 22nd of July 2013, I was told that the mother had tested negative for alcohol for some months. There were reports from Trimega showing her CDT, carbohydrate deficient transferrin, level was below the cutoff level of 1.6%, in fact 0.4% on the 26th of March 2013, 0.4% on the 12th of April 2013, and 0.3% on the 13th of June 2013. Between the 22nd and the 25th of July 2013, a further blood alcohol test report on the mother was received from Trimega. It was dated the 17th of July 2013, and the result for the mother's CDT level was 1.6%, just on the cutoff point between negative and positive results and an obvious increase on previous results. It was of great concern in that it indicated that the mother appeared to have been drinking when she was adamant that she had been abstinent from alcohol for many months. Her abstinence was a crucial factor in the plan for rehabilitation of the child to her care. The local authority therefore no longer supported such a plan. On the 25th of July 2013, I gave directions, having found it was necessary to have further expert evidence in accordance with Part 25 Family Procedure Rules 2010, for further blood alcohol testing by a different expert and for Trimega to report in respect of the interpretation of mother's alcohol testing results and for a new final hearing date. Trimega, in considering the significance of the raised CDT level as instructed after the 25th of July 2013, found that it had made a mistake and the CDT figure should have been 0.2% and not 1.6%. Trimega admitted the error and apologized then to the mother's solicitors by email dated the 9th of August 2013. An interim hearing was listed and on the 21st of August 2013 the child was returned to her mother's care under an interim supervision order in accordance with a new rehabilitation plan. The following orders were made, among others. The solicitor for the mother shall serve this order upon Trimega Labs, inviting it to attend at 2 p.m. on the 3rd of September 2013 to explain the error made in the blood test result dated the 17th of July 2013 and to address the issue of wasted costs should any party make an application for a wasted costs order. Any application for wasted costs shall be filed and served on the parties and Trimega Labs by 4 p.m. the 28th of August 2013. On the 3rd of September 2013, the care proceedings were finally disposed of by a supervision order being granted to the local authority and a residence order to the mother, together with other orders relating to the child. On the 30th of September 2013, I was told that the mother had been present outside court and an apology made to her by Trimega's representatives. All parties had filed position statements including their submissions. The court's power to award costs against an expert witness was not disputed by Trimega, and it agreed to pay costs in the total sum of £17,167, which related to 3 otherwise unnecessary court hearings. The only issue remaining was whether judgment should be published. All parties save Trimega sought publication. I heard oral submissions on that issue. I do not say that the error made by Trimega amounted to a flagrant reckless disregard of its duties to the court, and I accept it was a human error. I am reassured that the discovery of this error has led Trimega to add a new procedure whereby a further specific check is made back to source material before a report is finalized and its staff understands the importance of the new measure. Trimega accepts that the mistake should not have occurred and is keen to make sure it does not happen again, and it accepts that it was in breach of its duty to the court. Trimega accepts that the direct consequences were considerable upset and distress for the parents in this case, additional costs and not least a delay of 4 weeks for the child in being placed in her mother's care. Trimega has made its apology. I have decided to publish this judgment because I consider that it is in the public interest to do so. The family courts should be as open and transparent as possible to improve public confidence and understanding. In this case, expert evidence was relied upon, and if the mistake had remained undiscovered, it is probable, given the history in this case, that it would have led to the adoption of the child instead of rehabilitation to care of her parent. Close scrutiny of expert evidence is needed, and all the surrounding circumstances have to be considered in a situation such as this where the interpretation of test results was so important and influential.